My name is Renata Achebe. I am 32 years old. And the afternoon of my sister's bridal luncheon was when I finally understood that some people do not resent your failures, they resent that you don't have any. The private dining room at the Callaway Suites Hotel held 14 women that afternoon. My sister Vivian, her 6 bridesmaids, her future mother-in-law, 2 cousins from her fiancé's side, our mother, an aunt named Dorothea who had driven 3 hours for the occasion, and 2 friends from Vivian's graduate program whose names I had learned that morning from the escort card at the door. I was seated near the center of the oval table, between one of the graduate school friends and a woman named Petra Ose, who had been Vivian's college roommate and who was, as of 18 months ago, and entirely unknown to my sister, a colleague of mine at the firm where I worked. And seated directly across from me, in the chair assigned to the maid of honor, was the Honorable Caroline Marsh, retired Federal Circuit Judge, former chair of the State Bar's Ethics Committee, author of a judicial practice manual used in continuing legal education programs across 4 states, and the woman who had supervised my 2-year federal clerkship, attended my bar swearing-in ceremony in the 3rd row with a small bouquet of white roses she handed to me afterward, and written, at my request 7 years ago when I was 25 and sending out my first academic article, the foreword to the published version of my law review note on appellate procedure. My sister did not know this. Vivian and Caroline had met twice, once at a charity auction 18 months prior where Vivian had been on the planning committee, and once at a professional women's luncheon where Caroline had been a keynote speaker. To Vivian, Caroline Marsh was a distinguished retired judge she had cultivated as a social contact and considered a personal accomplishment to have as her maid of honor. She had announced the choice to our mother in October with the specific satisfaction of someone who understood the social weight of the name. She had not asked me whether I knew her. It had not occurred to her to ask. The luncheon had been proceeding pleasantly for about 40 minutes when Vivian began what she later described to our mother as just talking about the wedding. She had been discussing the timeline for the ceremony, the floral decisions, the hotel block for out-of-town guests. And then, in the way that Vivian had always had, a kind of lateral slide from one topic into another that made it difficult to identify exactly when the conversation had changed, she began talking about family, about the people who would be at the wedding and the people who would not, about dynamics, about history. She said that our family had always had a complicated relationship with the truth. She said that she had learned the hard way that not everyone in a family was who they presented themselves to be. She looked at me when she said it, not pointedly, not dramatically, but in the particular way of someone who wants you to know the statement is about you while retaining the ability to deny it was about you. And then she said, addressing the table generally but with her gaze still in my direction, my sister has been telling this family for years that she's a practicing attorney. Passed the bar, works at a firm, the whole story. I don't actually know how much of that is real. I'm not sure anyone does. A beat, and then, she's been lying to this family for years. About things bigger than this, if I'm being honest. I looked at my silverware. I picked up my salad fork and set it parallel to my dinner fork, aligning both with the edge of the charger plate. The motion took approximately 4 seconds. I set my hands in my lap. I took one breath through my nose, slow enough that no one at the table would have registered it as anything other than stillness. Across the table, Caroline Marsh had gone very quiet in the specific way of someone who has excellent self-command and is exercising it. What none of the 14 women in that room knew, except for Petra Ose, who had gone completely still beside me, was that the woman Vivian had seated in the position of greatest honor at her bridal table had more direct knowledge of my legal credentials than any document I could have produced. She had been present for the creation of those credentials. She had, in a formal judicial capacity, participated in them. I kept my hands in my lap. I waited to see what Caroline Marsh would do, to understand my sister's statement, and why she believed she could make it without consequence. You need to understand the specific structure of our family and the role that my professional life had played within it for the past 7 years. Our parents, Josephine and Bernard Achebe, came to this country in the late 1980s and built a life through a combination of my father's engineering work and my mother's decades-long career in hospital administration. They were educated, purposeful people who placed enormous value on professional achievement and who had, as many immigrant families do, concentrated that value in a particular child. In our family, that child was Vivian. Vivian was 4 years older than me, demonstrably charming, socially fluent in a way that I was not, and the recipient of a focused maternal investment that I observed from early childhood with the particular clarity of someone who understands they are watching something they are not part of. She was not cruel to me in those early years. She was largely indifferent, which is its own kind of statement. I was the younger one, the quieter one, the one who read too much and spoke too precisely and made adults at dinner parties say, "She's very serious for her age," in a tone that was not entirely a compliment. I was admitted to the State University's honors program at 17. I finished with a 3.94 GPA in political science and economics, which I paid for through a combination of merit scholarships, work study, and a part-time position at the university's legal aid clinic that I found in my second semester and held until graduation. The clinic work was where I understood, with the specific certainty of someone who has found the thing they are built for, that law was what I wanted to do. My family's response to my law school acceptance was muted in a way that required deliberate effort to maintain. My mother said she was proud and changed the subject. My father said, "Good, that's good," and asked whether I had talked to Vivian lately. Vivian, who was at that point completing a master's degree in arts administration, sent me a text that said, "Congrats. Big step." 2 exclamation points, no follow-up. I understood the register of each of these responses and filed them away and moved on. Law school was 3 years of work that I will not romanticize. It was difficult and expensive and frequently isolating, and I was good at it in a way that surprised even me. I made law review in my first year. I won a moot court competition in my second. In my third year, I was offered a clerkship with Judge Caroline Marsh of the Federal Circuit Court, a 2-year appointment that my clinic supervisor, a woman named Professor Adiz Nwosu, who had written my strongest recommendation, told me was the most competitive clerkship placement this program has produced in 8 years. I called my parents to tell them about the clerkship. My mother asked what a clerkship was. When I explained, she said it sounded like a good opportunity. My father asked whether it paid enough to cover my student loans. I told him it was a prestigious appointment that would significantly shape my career trajectory. He said, "Good, good," and asked whether I was eating properly. Vivian called 3 days later, after my mother had apparently told her. She said, "Mom said you got some judge job. That's cool." And then, "I'm thinking about proposing a new programming series at the museum. Can I run some ideas by you?" I said yes. We spent 40 minutes talking about her programming series. I clerked for Judge Marsh for 2 years. I will tell you plainly that those 2 years shaped me in ways that are difficult to quantify, not because I am being sentimental, but because clerking for a federal judge at that level, with a jurist of her precision and intellectual rigor, is a genuinely formative experience. She expected a great deal. She was not warm in any conventional sense. She was fair, exact, and demanding, and she treated my work with the specific seriousness of someone who believed that the work mattered. I learned more in those 2 years than I had in 3 years of law school. I passed the bar during my clerkship, California, first attempt, in the 81st percentile. The swearing-in ceremony was held at the courthouse. Judge Marsh attended. She sat in the 3rd row. She handed me white roses afterward and said, "Don't embarrass the clerkship." I told her I would do my best. She said my best had been adequate so far. I have thought about that moment many times in the 7 years since. After the clerkship, I joined Hartwell Breckenridge LLP as an associate in their appellate practice group, a mid-sized firm with a strong appellate reputation and a client base that included several institutional clients Judge Marsh had worked with during her time on the bench. She had not referred me. I had applied through the standard process and received the offer on the merits of my clerkship record and writing sample. She wrote a recommendation when asked. The recommendation, I was told by a partner during my offer call, was unusually direct. I had been at Hartwell Breckenridge for 5 years at the time of Vivian's bridal luncheon. I was a senior associate. I had a caseload. I had a bar number. I had a published brief with a foreword by the woman sitting across from me. My family knew I was a lawyer in the way that families know things they have not fully processed, as a fact that had been stated, that sat in the available information, that was not integrated into the working story they told about each other. My mother sometimes told her friends I worked in law. My father occasionally introduced me as my daughter, the attorney, with the particular intonation of someone reading from a card. Vivian told people I did something legal when the topic arose, which was rarely. I had stopped trying to explain what I actually did approximately 4 years prior. Not out of bitterness, out of the recognition that the explanation required more sustained attention than the conversation was going to provide. What I had not anticipated was that Vivian would move from not understanding my career to actively disbelieving it. That transition, when I look back at it, had a specific origin point. 14 months before the bridal luncheon, Vivian's museum had faced a contract dispute with a vendor, a catering company that had invoiced for a gala event at a rate that exceeded the signed contract by a significant margin. Vivian had called me, agitated, and asked what she should do. I told her to pull the original signed contract, document the discrepancy in writing, send a formal dispute letter to the vendor citing the specific clause that governed pricing, and copy the museum's legal counsel on all correspondence. I walked her through the dispute letter line by line. I told her what language to use and what to avoid. The dispute was resolved in the museum's favor within 3 weeks. The vendor withdrew the excess invoice. Vivian did not thank me. She sent me a text that said it worked out, and then, 2 days later, called to tell me about a disagreement she'd had with one of her bridesmaids about the bachelorette weekend. The contract dispute was not mentioned again. 8 months before the luncheon, my mother mentioned in a phone call that Vivian had told her I had helped with some paperwork for the museum dispute and that Vivian thought I must have looked something up online. I asked my mother to repeat what she'd said.
She did.
I asked her whether she had told Vivian I was a licensed attorney. She said she thought Vivian knew that. I told her Vivian had described what I'd done as looking something up online. My mother said Vivian was probably just simplifying for conversation purposes. I did not call Vivian about it. I noted it. I filed it in the working understanding I had been building for years about how my professional life was processed in my family of origin. 3 months before the luncheon, at a Sunday dinner at my parents' house, Vivian made a comment in front of our father, our Aunt Dorothea, and our cousin Marcus about whether I was actually at a real firm or whether I just helped people with contracts or whatever. My father made a non-committal sound. My aunt changed the subject. Marcus, who is 24 and had his own reasons for not engaging with Vivian's conversational architecture, looked at his plate. I said, "I'm a senior associate at Hartwell Breckenridge. Appellate practice. I've been there 5 years. Vivian said, "Right, I know. I'm just saying it's not like you're like a litigation attorney or whatever." And then, turning to our aunt, "Dorothea, did you end up getting the caterer sorted for the wedding weekend?" I picked up my water glass. I drank from it. I set it down. That was 3 months before the luncheon. Caroline Marsh held her wine glass for approximately 8 seconds after Vivian finished speaking. I know it was approximately 8 seconds because I counted them the way you count things when you are holding yourself very still and need something to measure. Then she set the glass down. The stem made a small sound against the tablecloth. She looked at my sister. Then she looked at me. Then she looked back at my sister with the expression I recognized from 2 years of watching her look at attorneys who had said something she was about to correct. "Vivian," she said. Her voice had the register it always had, level, unhurried, the voice of someone who has spent decades in courtrooms where the person speaking controls the temperature of the room. "I want to make sure I understand what you've said. You're suggesting that Renata has misrepresented her legal credentials to your family." Vivian's expression shifted in a way that was difficult to categorize, not alarm, exactly, but the beginning of a recalibration. "I mean, I'm just saying we've never really verified." Renata Achebe, Caroline said, was admitted to the California bar in October of the year she completed her clerkship with me. Her bar number is 387214. She passed on her first attempt in the 81st percentile. I attended the swearing-in. I have attended a great many swearing-in ceremonies. I attended hers specifically because she had been one of the 2 finest clerks I supervised in 11 years on the bench. The table was very still. "She has been a licensed attorney for 7 years, Caroline continued. "She is currently a senior associate at Hartwell Breckenridge, which is a firm with a serious appellate practice. I wrote a recommendation for her when she applied there. I also wrote the foreword to her published law review note, which is cited in at least 3 subsequent articles I'm aware of, though she would know the current count better than I would. She picked up her wine glass again. I don't know where the uncertainty about her credentials originates, but I want to be clear that there is no uncertainty about the credentials themselves. There is a public record. Across the table, my sister had gone very still. Her fiancé's mother, a woman named Helen Okafor, who had been pleasantly reserved throughout the luncheon, had put down her fork. Petra Ose, beside me, had her hands folded on the table in front of her and was looking at the centerpiece with tremendous focus. I said nothing. I kept my hands in my lap. I looked at Caroline. Our mother, 3 seats to Vivian's left, made a small adjustment to her napkin, the same gesture she made at every family event when something had been said that she was not going to address directly. Vivian said, "I wasn't trying to. I just meant." "You don't need to explain it to me," Caroline said. And then, turning slightly in my direction, "Renata, I believe you were going to tell us about the Callaway appellate filing. Petra mentioned you had an interesting development on that matter." She had not mentioned this before. She said it with the specific authority of someone redirecting a courtroom, and the table accepted the redirection the way rooms accept things said by people with that kind of authority. I said, "The Ninth Circuit issued a favorable ruling on the procedural question last month. It's likely to affect how similar motions are filed across the circuit for the next several years." Helen Okafor asked what that meant practically. I explained. She asked a follow-up question. I answered it. The luncheon continued. Vivian did not speak to me directly for the remainder of the meal. She was present and social and managed the transition to the dessert course with the professional hostess capability she genuinely had, but the specific frequency she normally directed at me, the monitoring quality, the lateral attention, was absent for the rest of the afternoon. Caroline and I walked to the hotel lobby together when the luncheon ended. She waited until we were through the dining room door before she said anything. "Your bar number," she said. "Do you actually know it by memory?" 387214, I said. "I don't know mine," she said. "I looked yours up this morning." I looked at her. "Petra called me last week," she said. "She said she was concerned about some things your sister had been saying and thought I should know the seating arrangement before I arrived." She paused. I thought it was worth being prepared. I stood in the lobby for a moment with that information. "Thank you," I said. "The forward citation count," she said. "What is it currently?" 11, I said. She nodded once, the way she nodded when a brief had cited an adequate number of supporting authorities. Then she said goodbye and walked toward the elevators. The consequence cascade moved in several directions at once, and I did not orchestrate any of them. The first consequence was the one I learned about from Petra 2 days after the luncheon. Helen Okafor, my sister's future mother-in-law, had asked her son, Vivian's fiancé Thomas, about the family dynamics she had observed at the luncheon. Helen was a family medicine physician with a practice group of her own, a woman who had built something over 20 years and who had, as Petra described it, a low tolerance for people who undermined other people's professional credentials in social settings. Thomas had apparently had a long conversation with Vivian following the luncheon. Petra did not have the specifics of that conversation, but she knew its general character because Thomas had asked her, as a mutual colleague of mine, whether what Caroline had said about my career was accurate. Petra had sent him a link to my firm biography page and my published law review note, and the foreword Caroline had written. Thomas had thanked her. He had not, to Petra's knowledge, shared any of this with his mother directly. He had not needed to. Helen Okafor had done her own searching. The second consequence arrived through our mother. Josephine Achebe called me 4 days after the luncheon, on a Thursday evening. She spoke for about 6 minutes. She told me that Vivian had called her the day after the luncheon and had been very upset by what she described as Caroline humiliating her at her own event. My mother said she had told Vivian that Caroline had simply clarified a factual matter. Vivian had said that the factual matter should have been handled privately. My mother had asked Vivian, for what I understood from context was the first time, to explain precisely what she had meant when she said I had been lying to the family for years. Vivian had not had a clear answer. My mother told me this in the specific tone she used when she had arrived at a conclusion she was not comfortable with and was not yet ready to state directly. She said, "I didn't know you had published something." I told her I had. She asked what it was about. I explained appellate procedure in accessible terms. She was quiet for a moment and then said, "I should have asked more questions." It was the closest thing to an acknowledgement I was likely to get from my mother, and I understood it as such. The third consequence was professional, and it arrived last. Judge Marsh, retired, but not inactive, sat on 2 advisory boards and maintained a lectureship at the law school where I had studied. She also, I learned approximately 6 weeks after the luncheon, had mentioned to Professor Adiz Nwosu, my former clinic supervisor, who remained a professional contact of hers, that she had recently spent an afternoon with one of the clinic's most successful alumni and had been reminded of how strong the program's pipeline was. Professor Nwosu had written to me the following week asking whether I would be willing to serve as a guest lecturer in her advanced legal writing seminar in the spring. I said yes. The invitation was circulated in the law school's alumni newsletter. My mother saw it. She forwarded it to me with a message that said, "I didn't know you were teaching." I wrote back and told her it was a one-time guest lecture, not a teaching appointment. She wrote back and said she had told Dorothea about it. Vivian's wedding went forward 6 months after the luncheon, at a venue on the waterfront that she had been planning for 2 years. I attended. I wore a dress I had bought specifically for the occasion, a deep burgundy one that I had chosen with no associations attached to it. I sat in the 4th row on the bride's side. Caroline Marsh was in the front row as maid of honor and moved through her role with the composed efficiency she brought to everything. When Vivian walked down the aisle, she looked genuinely radiant. She is, for all the complexity between us, a woman who had wanted this particular moment for a long time, and she inhabited it fully. I watched the ceremony from the 4th row and found that I was able to hold 2 things at once: the fact of what she had said at the luncheon, which I had not forgiven, and the fact that she was my sister getting married, which was real and not nothing. I did not resolve the tension between those 2 things. I let them both be true. At the reception, Caroline found me at the cocktail hour. She handed me a glass of sparkling water. She had noticed, sometime during the clerkship, that I did not drink at professional events, and had apparently retained the observation across 7 years. She said, "The 4th row was a dignified choice." I said I thought so too. She said the ceremony had been well organized. I agreed. She moved on to speak with someone else. It is now 14 months after the bridal luncheon. I am still a senior associate at Hartwell Breckenridge. The 9th Circuit ruling I mentioned at the luncheon has been cited in 14 subsequent motions across the circuit, a number I track because I am the person who wrote the brief. I gave the guest lecture at Professor Nwosu's seminar in March. I have been invited to give a second one in the fall. My relationship with Vivian is functional. We speak at family events and occasionally by text when logistics require it. She has not referenced the luncheon. I have not referenced it. There exists between us the specific truce of 2 people who are not going to resolve something, but have arrived at a working arrangement around its absence. My mother asks more questions now. Not many and not always the right ones, but more than before. My father attended a bar association event I was listed as a speaker at, not because I invited him, though I did, but because my mother apparently decided he should go. He shook my hand after my remarks with an expression I recognized as pride that he was not sure how to deliver. I thanked him for coming. He said the room seemed impressed. I said I thought it had gone well. I think about Caroline handing me white roses at the swearing-in, and I think about her looking up my bar number the morning of the luncheon, and I think about how 7 years passed between those 2 moments, and she had remembered the number anyway. I have not told her that I think about it. I don't think she would find it remarkable. What you know about yourself is not diminished by someone else's refusal to know it. My bar number is 387214. It is in the public record. It has been there for 7 years. 14 months ago, a retired federal judge said it out loud at a bridal luncheon, and the number did not change, and the career behind it did not change, and the 7 years of work that produced it did not change. The only thing that changed was that 12 other women in a private dining room heard it stated by someone whose professional habit was to state things accurately. That was enough. Here is what I keep returning to, and I'd like to know if you've lived something close to it. There was a moment, in the 8 seconds between when my sister finished speaking and when Caroline set down her wine glass, where the entire table was waiting. If you have ever been in a room where someone with authority to correct the record was deciding whether to use it, what did that silence feel like before they spoke? Leave a comment. Share this with someone who has had their credentials questioned by the people who should have been their loudest advocates. And if you haven't subscribed yet, there are more of these stories, and the next one is already here. I'm Renata Achebe. Bar number 387214. The record is public, and it always was.